We'll now take up Bill number 5469 by Chairman McNamara. We're going to wait. We'll wait on that. Does he want me to do his bill with him not here? Okay, Bill number 5469 by Chairman McNamara. This act would allow information contained in the prescription drug monitoring database to be disclosed to a certified law enforcement drug diversion investigator of a qualified law enforcement agency who has completed a certification course approved by the Director of the Department of Health and certified by the Police Officers Commission on Standards of Training. And I am told that the AG's office is here to speak on this bill. Matthew, would you like to up to the podium? Welcome.
Thank you, Chairman and members of this committee. I'll try to be brief on this bill. So last session, we also introduced a bill to reverse some of the changes that were made in a 2013 legislative session. A search warrant requirement was amended into the electronic prescription monitoring database. Prior to that amendment, local, state, and federal law enforcement personnel would routinely contact the Department of Health for information in the PDMP in relation to active bona fide investigations. We sought to reverse the search warrant to that active bona fide investigation standard because since the search warrant requirement became law, investigations from local and state law enforcement, our Medicaid fraud unit, and the federal government were impacted severely. It slowed down the investigation process. It took up a lot of resources, and we're not moving as fast as we were. That's especially important now since Rhode Island is in the center of the storm for heroin, fentanyl, and prescription opiate overdoses. It's a serious epidemic here in the state of Rhode Island. So we were looking to go back to that prior standard. Last year, we listened to the committee, the concerns of this committee, as well as the concerns of those who testified, and we completely rewrote the bill. We changed it, so we addressed what we feel we addressed and tightened the scope of the legislation. What this bill would do is it would provide a certified law enforcement prescription drug diversion investigator. And what that means is a certified law enforcement officer assigned by his or her qualified law enforcement agency. The qualified law enforcement agency would have to go through some type of approved training by the Department of Health and certified by the Police Officers Commissions on Standards and Training. Brandeis University, they do an excellent guide for training law enforcement. Also, Arkansas, who passed a similar bill to this, we modeled this bill on Arkansas law. They have a training system in place. So the training system's there. It's good. It's part of Brandeis's Center of Excellence on the PDMP. I can share this with the committee, certainly. So that certified law enforcement prescription drug diversion investigator through the certified law enforcement agency would be approved by the director to be able to access the PDMP in relation to active investigations. The qualified law enforcement agency that the certified investigator works for would have to submit to the DOH an annual report of the data accessed by all certified law enforcement prescription drug investigators, and include without limitation written verification of what the inquiries were, what was provided to the department through the case number of the investigation, and the disposition of the investigation. So that highlights the concern last year that law enforcement would essentially have unfettered access under the Department of Health. Would control that, they'd oversee that, they'd be able to revoke if somebody is exceeding their authority. The DOH would create a verification form that would have to be submitted annually from that law enforcement agency. If the law enforcement agency didn't submit that verification form within 30 days, they would have their access stripped. It's important to note that law enforcement already has access to this information. It's guidelines under the DEA. They can go into any state pharmacy and access this information already. The problem is it takes a lot of time and a lot of resources. That's why this PDMP provided a sole source of information we already had access to. This just put another step in the process, so we're trying to address that. Like I said, this PDMP law is based on current law in Arkansas and based on current regulations in the Department of Health in Massachusetts. So Massachusetts does something almost exactly the same of what we're asking for, and they do it through regulation, not through state law. We're asking here for this to be in state law. I do want to bring up one other point. I know at some point there'll probably be somebody who gets up here and talks about Fourth Amendment concerns. I want this committee to understand that there's been no case law, to my knowledge or to my office's knowledge, of any court in this jurisdiction that has extended Fourth Amendment protections to this type of information. There simply just isn't a case on point. The current regulations in Massachusetts have never been challenged. They do this exact same thing we're asking for. Arkansas, there has been no challenges. So the Fourth Amendment concerns, I just think, are unwarranted and used basically as a scare tactic. With that, we would urge this committee to pass this legislation so that we can better go after drug traffickers who are causing harm to our citizens. And if you have any questions, I'd be happy to take that.
Any questions of the witness? Thank you. Oh, okay.
So, thank you. I appreciate because I like the changes you guys have made since last year too. I think it's a little bit narrower. You've got more of a designated party in the police department as opposed to being potentially all police. And because I thought that was my concern, at least with as it was written last year. But one thing is that verification. It doesn't look like how do they get reinstated after they've had it suspended? It looks like they just basically submit it whenever they submit it, even if they're 30 days late. Okay, they're suspended, but now they give it out 2 days later. Now they're reinstated. Is that a fair characterization, probably, of how that works?
Yeah, you know what? I can get you that answer. I want to check with our Medicaid fraud unit who helps us with this bill, but I can get that answer.
But again, so that the section that talks about written verification at the inquiries, that's part of the annual. This section, this 2A, section. The part that annual thing is connected to is all this stuff down below is an annual thing, right? Where it
Correct.
Says, so written verification at the inquiries are part of a lawful prescription. All that stuff is going to happen when you're okay. That's what I was trying to get a sense along the way.
Certainly.
Thank you.
Any other questions for the witness? Thank you.
Thank you.
Matthew. Next witness is David Heckman from the Department of Health. Oh, he won't be speaking? Okay. 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 Thank you. Christy Dupart?
That's Christy Durant. She's in my firm. I signed up also.
Okay. So she won't be speaking? Okay. Thank you, sir. And I can't read the writing of this one. Rhode Island Medical Association. Ditos? Steve DeToy? He
has written testimony.
Okay. So Steve Brown, ACLU.
Thank you again, Chairman, members of the committee. On behalf of the ACLU of Rhode Island, I'm here to express our strong opposition to this legislation. As you heard, in 2013, this body enacted a law requiring that a warrant be issued in order for law enforcement to be able to gain access to what is very private information, all of your medical prescription information that is in this electronic database. And it was put in at a time when, at the same time that the legislature expanded the types of drugs that had to be included in the database. So right now it includes Schedules 2 through 5. It includes your asthma inhaler, your cough syrup, your Xanax. All of that is in this database. And what this bill proposes to do is to allow law enforcement to gain access to that information based on their conducting an investigation. We believe a warrant requirement is essential. If there really is a basis for wanting to look to get this information, we do not think it's a huge step to require the police to get a warrant, as they're generally required to do in all sorts of other investigations that are just as critical, if not more critical, than gaining access to this type of record. We urge this committee to stick to what it did in 2013, recognize the importance of having an independent arbiter, a judge, decide that there is in fact a basis legitimate basis for gaining access to this private information, rather than leaving it up to law enforcement to make that decision. I'll be glad to answer any questions.
Any questions of the witness? Thank you, Steve. Randall Rose signed up to speak. Randall? Randall's not here. And last is Rick from the Blue Cross. Gulfman? Yeah. Welcome.
Chairman, members of the committee, Rich Glucksman from Blue Cross Blue Shield of Rhode Island. Blue Cross has been very active in the community as well as on governmental task forces looking at overdose and abuse, including with Representative Bennett, who's on the committee. We wanted to voice our support for the Attorney General and for this bill. We use some of our own data and information gathering to try to identify possible fraud or abuse of substance abuse, including, as was mentioned, the opioid overdose epidemic that we're in now. So when we look at our own data, and it doesn't give us the entire picture of the community, but at least what claims have come through, and then we make a referral to the Attorney General's office or to law enforcement, this will give them a better, they'll be better equipped to gather data and to take appropriate action. So for that reason, we support the bill. Thank you.
Thank you. Any questions of the witness? Thank you very much.
Thank you.
Sure.
And my name is Patrick Quinlan. I'm here today on behalf of the Rhode Island Dental Association, the oral and maxillofacial surgeons, the anesthesiologists, and radiologists. We disagree with this legislation respectfully. We're well aware of the opioid crisis, and we're working very hard to deal with that. What this is, it really is an unprecedented invasion of the patient's rights when you think about it. This is protected health information under federal law and under state law. You can't get it. If a doctor releases it by mistake, if a hospital releases it by mistake, they are liable for severe penalties and damages under the law. You know, and the AG's office made a point of saying that there's no, and they carefully worded, there is no legal authority in this jurisdiction that says the Fourth Amendment would apply to such data. There is a case currently on its way through the Ninth Circuit Court of Appeals, the Federal Court of Appeals, on this very issue. There, the DEA had served administrative warrants and seized data. They tried it. The trial judge essentially ruled that it was a violation of the Fourth Amendment. The Ninth Circuit just heard arguments on it in November. We're expecting a decision soon. You know, I really don't think that the model that we all should be following is whatever Arkansas does. I understand Massachusetts doing it, but there was a long process involved in that. But what concerns me is someone just pouring through and looking at any of your, mine, my children's medical records, essentially. These are some of our most private moments. We used to always say, let's keep the police and law enforcement out of the bedroom. Now I'm here to say, let's keep them out of our medicine cabinets. Because if there is a pattern, last year you enacted comprehensive legislation that allowed the health department to look for patterns of inappropriate prescription, etc. They have every right to pick up the phone and call the AG's office. You know, the fact that we're going to have a training course, someone goes to Brandeis or goes to Arkansas for a few days for a training course, doesn't really put to rest our concerns over this most vital and private information. You know, I think we could all say we have nothing to hide, but on the other hand, do I really want someone pouring through prescription records without a warrant? A warrant is an independent judicial officer. The AG can get a warrant in about 20 minutes if they have something. I was a prosecutor. Pardon me? Okay. I was a prosecutor. We regularly got warrants in the middle of the night when we needed them. So, thank you.
Thank you very much. That's going to conclude the hearing on House. Oh, I'm sorry.
Thank you, Mr. Chairman. Wouldn't the patients be protected by the HIPAA laws? I don't see anything or hear any conversations around that.
That is our contention, but when it's a law enforcement agency, there's no specific provision in HIPAA that deals with that. I represent a lot of health professionals. For example, when someone issues a subpoena for medical records in the family court, I will represent different health professions because you have to give the patient 20 days advance notice by federal law that their records are being subpoenaed. Administrative subpoenas, at least in the West Coast, have been tossed, and they're now in front of the Ninth Circuit. So there is no specific prohibition on this, and I think we trust warrants for everything else, for someone coming into your house in the middle of the night, For all of these other issues, we trust judges to make that decision, and we think this is such personal information that same protection should apply.
Chairman, one more.
Yep.
Yeah, I had one other one.
Chairman Handy.
I feel like you gave me some history on this. Again, it's narrowed a little bit. That's why I appreciate it. But did you tell me that before we put this in place, or maybe it wasn't, maybe it was even somebody else, but maybe you can educate us, that a lot of that sort of Schedule 2 through 5 stuff wasn't actually in the statute, that a lot, like in other words, they weren't able to go out and find out what somebody's Xanax or asthma inhaler stuff was in the previous iteration of the law before we did this?
I did not. That might have been the representative from the AG that it was, when it was limited to Schedule 2s, they had access, or Schedule 1, I think that was from the AG, and I mean to testify for them. And then it was expanded 1 through 5. But still, if I go get pain medicine, why is that local law enforcement to sort through my medical records?
Thank you.
Thank you. Representative Welch?
And my question is just specifically, does this only apply to, I know that the AG's office was saying it's specifically to curb the opioid deaths. Is it specifically for drug-related cases? Because I didn't see any language there that made it specific to. My concern would be somebody who's on antidepressants who perchance is in a custody battle, then of course, that's all fair game or something along those lines. Is it specific to drugs or is it?
No, I believe it's Schedules 1 through 5, and I defer to the authors of the bill here and to the chairman.
Enforcement investigation only, so a custody scenario wouldn't be.
Sure, sorry. But I mean, is it just for drug cases or is it for any ongoing investigation?
The way it's written, it would be for all law enforcement investigations.
Any other questions of the witness? Thank you, sir.
Thank you.
That's going to conclude the hearing on 5469.
Item 5, number 5469, sub A.
Chairman McNamara.
Thank you, Mr. Speaker. 5469, substitute A by myself, would amend sections dealing with the electronic prescription database to provide certified law enforcement, prescription drug and diversion investigators access to this information. Mr. Speaker, the sub A limits this information to the FDA, DEA, FBI, OIG, which is the Office of Inspector General, and the federal office, and the Attorney General's Medicaid Fraud Unit. Local enforcement, state police and local police, would still have to seek a search warrant. Also, these may be requested from the Department of Health. Law enforcement will not have access to the prescription monitoring database. There's a 5-year sunset provision in this, and the Department of Health can end the program at any time. Mr. Speaker, every community in our state has been touched by the opioid and prescription diversion epidemic. This is an attempt to end that diversion. I believe we can do more, and I move passage.
Chairman McNamara moves passage. That is seconded by Chairman Corvesi, Representative Bennett, Representative Marshall, Representative Johnson, Representative Shanley, Representative Falella, Chairwoman Ruggiero, Chairman Abney. Representative Shanley.
Without objection, Mr. Speaker, may I be recorded in the affirmative on items 1 through 12 on the prior calendar, please?
You may, so ordered. Whip Philippi.
Thank you, Mr. Speaker. Would the chairman yield, please?
He will yield. Proceed.
Thank you, Speaker, and thank you, Chairman. So, just to be clear, this authorizes law enforcement to view someone's prescription history?
This authorizes the FDA, DEA, FBI, OIG, and the Attorney General's Medical Fraud Unit to request from the Department of Health, their designated person, information that may be in the prescription monitoring database.
And that would include the patient's name?
Yes.
Okay. Thank you, Mr. Chairman, and
You're
thank
welcome.
you, Speaker. Mr. Speaker, I strongly oppose this bill. I think we have such a heightened expectation of privacy in our medical records that if this information is relevant to an ongoing investigation, go through the warrant process, go to a judge, say, here's our probable cause, we want a warrant for this information. I'm very skeptical about handing over confidential patient information to an agent of law enforcement without a warrant. I understand that this is held by a third party, and maybe there's arguments that the patient no longer has control of that information, and maybe there shouldn't be a warrant requirement, but this is highly confidential information. There's got to be judicial oversight before this information is disseminated to law enforcement. I think it's clear, and I cannot support this bill. Thank you, Mr. Speaker.
Representative Bennett.
Thank you, Mr. Speaker. This kind of monitoring is going to be looking for criminal activity. They're not just going to be going through people's prescriptions and looking for somebody who's getting Vicodin. They're going to look for somebody who's getting a lot of Vicodin. They're going to be looking for the doctor who's giving a lot of Vicodin. The pharmacist who's doing the same thing. You're going to be a criminal. The FBI is not going to waste time, or the DEA, on coming down looking at a regular prescription. They have to have a reason to look in the first place. Thank you, Mr. Speaker.
Representative Almeida.
Thank you, Mr. Speaker, members of the House. I got a question for the chairman.
He will yield. Proceed.
So, the good rep, Blake just took some of the wind right out of me, and he's right. So, explain something to me. What happens to the warrant process? I'm confused. I mean, are we giving that much power to the AG of all people?
So, local police officers, the state police, would still have to get a warrant.
Let me hold you right there.
Yeah.
That word local police. Are you talking municipalities?
Right.
We have to get a warrant.
Correct.
But that warrant process disappears when?
With these specific groups, FDA, DEA, FBI, OIG, and the Attorney General's Medicaid Fraud Unit, the unit that investigates prescription fraud.
So
those entities do not have to get a warrant.
So there's a law enforcement divide between municipalities and state and feds. That's what there's a divide here. They are dividing us.
Correct. Just those entities can get that information without a warrant.
Without a warrant.
Correct.
Why?
In 1999, the Rhode Island Superior Court case, State versus Underwood, that a criminal defendant has no expectation of privacy in his prescription records because they were produced by medical personnel for use in providing medical treatment. These are not the defendant's personal papers created or kept by him. They can demonstrate neither ownership nor possession. It's based on state law, court case that was established, and these are people who are under investigation by the FBI for taking prescriptions, selling them in the street, diverting them. They are part of the problem. So the DEA and the FBI have the authority, whereas local police departments, the state police, if they have evidence, they apply for a search warrant, and they can go through that process.
So how long ago was this court case? How many years or a year?
1999.
So the AGU's offices waited almost 20 years to make a decision on what we're talking about today.
In 2013, Representative Almeida, we amended the current law, which at that time did not require a search warrant for access to these records when there was suspected criminal activity. In 2013, we amended the law. We think we went overboard at the time. Other states currently do not have that.
How many other states do this?
I believe Connecticut and Massachusetts. 30.
30 states?
30 states, including Connecticut and Massachusetts.
I'm still stuck on this
Okay.
this 20-year period. Thank you, Mr. Chairman. I appreciate
My
it.
pleasure. Thank you.
Mr. Speaker, my whole issue is this. The Attorney General's office in Rhode Island finds the time and the resource and the money and the power to go all through this country with the 30 states. But this Attorney General's office has a civil rights division that's sitting there with mothballs. It's sitting there where there's all kinds of issues going on in this state that they haven't even faced. I understand at the city council level, and even up here, but the city council level kind of looks at the quality of life for people. But we too look at the quality of life. My good brother Blake just brought up some good issues. And it goes back to the Attorney General's office can decide when they want to get on board when the civil rights unit in that office has been sitting there with nothing happening. And if it is, you sure don't hear either about it in the Pro, Joe. That being said and done, ladies and gentlemen, it's interesting how we want to, in this state, enforce laws that we want to enforce or what we think is good for the people. I'm still questioning, since I've been up here, which people, how many people, and who are they? And I got a problem with dividing law enforcement from a municipality to a state agency. When all of us, whether it's in the city of Providence, which I'm so proud of being able to wear that brown then blue uniform, and then I retire, but I still see the same thing that I saw when I left, that constant divide. There is no unification law enforcement. There may be for some law enforcement officers who are politically strong, but for the rest of us who what I call a good street cop, whether you like it or not, the job got done. But civil rights is still taking a back seat to something like this that does not get enforced or even gets looked at. Don't vote for this. Thank you, Mr. Chair, Mr. Speaker.
Leader Morgan.
Thank you, Speaker. I think if Representative Bennett is right that this is looking for criminal activity, that it would seem that it was even more important to have a warrant, not less. That is the due process rights that we have. Another constitutional right that shouldn't be taken away. Thank you.
Representative Chippendale.
Thank you, Speaker. The protections we enjoy under HIPAA and generally surrounding all of the medical care that we as consumers may partake in is absolute. That's something that is private. It should be private. If there are individuals who are behaving in a criminal manner, we're giving folks on the state level, law enforcement on the state level, a pass. They have to still go through the courts, through due process. They still have to file for a warrant, and they still have to go through the criminal investigation process. But we're saying the feds can just come right in and access the history of an individual and determine on their own whether or not there's any sort of criminal activity. Well, I would tender the idea that this is best caught on the local level. Why would we tie the hands of local law enforcement or investigatory bodies in the state? And more so, why would we reveal the most sensitive information a person may have in their lives, in their history? We're going to open that up under the guise of trying to catch people who are doing things wrong. And there are people who are doing things wrong. No argument there. There are ways to catch them. We've seen cases in the Journal where doctors have been banged for over-prescribing. They have the tools to do it now without violating the sanctity of privacy in medical records. That, my friends and colleagues, is the camel's nose under the tent. We can't do that. We do that, that's a slippery slope. I can't urge you more strongly to vote against this. Thank you.
Whip Philippi.
Thank you, Speaker. And I'd like to unpack a little bit the reference to the Superior Court case that Chairman McNamara stated, I think that analysis was under your constitutional Fourth Amendment right to not be subject to unreasonable search and seizure. And it is true that the records are held by a third party, so you don't hold a personal right to that. But we have to remember that constitutional protections are the bare minimum protections that we are entitled to as citizens and people who live in the United States. We can always provide stronger statutory protections in excess of constitutional protections. And we have previously. If you look at lines 29 through 31 on page 7, we already have a search warrant procedure when agents of the state want to access this information. It already exists. This is extreme privacy that we're violating here. You know, a lot of times in the name of expediency, we infringe on people's rights. We infringe on privacy. I think we did it yesterday or a couple days ago with cameras out there in the name of expediency, and we're doing it again with this highly personal data in the name of expediency. There's a process in place to get a warrant. Let's respect people's privacy. Let's follow that process. If the police think they have enough information based on probable cause to get a warrant, go to a judge and get it. Why infringe on people's privacy in the most personal things they have, their medical records? This is a bad idea. Thank you, Mr. Speaker.
Representative Walsh.
Thank you, Mr. Speaker. I also, for once, maybe we should mark this on a calendar, agree with Representative Filippi. I was in the committee on where this passed, and there are a number of problematic things that I find about this bill. The first being that it's opposed by 15 different organizations, including but not limited to the Rhode Island Medical Society, the Rhode Island Health Center Association, Rhode Island Dental Association, Society of Anesthesiologists, et cetera, on and on. And also the ACLU. The Department of Health has identified the top 400 prescribers, and there were no referrals to law enforcement in the state of Rhode Island, which leads me to believe that they're not just looking for pill mills. If you are a pessimist and think about this in the worst case scenario, this could really damage somebody's reputation. It could damage their careers, and it could damage their lives if it's not done appropriately. And the reason that we have search warrants is so that you can prove beyond a reasonable doubt that this person is, you know, an imminent threat to our society and the way that we view it and live it. I respectfully am going to vote no on this because I think that it's a little creepy. I think that Big Brother looking into my prescription history is a little more jurisdiction than they should have. So I will be voting no on this. Thank you, Mr. Speaker.
Representative Almeida.
Thank you, Mr. Speaker, gentlemen, ladies and gentlemen of the House. A question for the chairman again.
He will yield. Proceed.
Yes. The 15 organizations that Rep. Walsh has talked about, did those folks drop letters of concern? Did any of them testify in regarding this bill?
Several of them sent letters of concern, but also they sent letters before the bill was amended to require local individuals to apply for search warrants.
Did any of them testify? Did you say exactly?
The ACLU.
Just the ACLU. Thank you, Mr. Chairman. Ladies and gentlemen, we got 15 organizations that are concerned about this bill. I don't know the names of all of them, but when are we going to start taking opinions from organizations that have the respect, as the HIPAA Act was just talked about a second ago here? In the medical field, I'm sure, and I don't want to speak for my good brother here, but, you know, they're saying, hey, and I'm paraphrasing, we got a problem. Why should we be doing this? Why should we get involved? I'm very concerned about this when we're starting taking, we got 15 organizations, I'm sure that they're well respected, well known. But I've said it before in my last debate, and I went off on all y'all, when we all got elected, that the famous quote here is the House of the people. The Attorney General works for the people. Has that been vetted throughout all organizations, be they community organizations, were minority organizations asked to weigh on this? Hell no. There was more bull chips on this thing than any of us can deal with. House of the People should in fact be involved, and they were not. And there were 15 well-known organizations that testified in some sort of way against this bill. Civil rights, again, is taking a back seat in the House of Representatives for the House of the People. Thank you, Mr. Speaker.
Representative Canario.
Thank you, Mr. Speaker. I rise in strong support of this bill. There's one thing we're losing sight of here, ladies and gentlemen, is the fact that these 15 organizations that oppose this bill, or supposedly oppose this bill, are actually associated with writing the prescriptions that's causing the problem. Of course they're going to oppose the bill. The problem we have here is these people are obtaining drugs, sometimes prescription shopping, going to see several doctors, and they're going to end up with a pile of barbiturates or whatever it may be. Yes, they're probably going to not support the bill because perhaps they're part of the problem. And what are we trying to do here as the House of Representatives? We're trying to keep people safe. We're not out there. We don't care about their well, we shouldn't say we couldn't care, but people may have health concerns that have medication to treat that is fine. It's the abusers. It's the abusers. It's the drug dealers. It's people that are getting loads of these drugs to sell them on the street. That's what they're trying to prevent. They're not going to...
Wait, hold on a minute. Hold on a minute, Representative. Calm down. Let's everybody calm down. Please calm down. I know you're hollering. Please calm down. Calm down. What is your point of order, Representative? Use your microphone, please.
To paraphrase this good representative, and he is a great sergeant, but the other point of this issue, the way he sounded as if I'm supporting drug dealers. I am not supporting drug dealers. I put my fair share away.
Representative,
wait a minute, I have the right to be heard, and the point of my point of order is that we're talking about the merits of the bill that deals with other issues in which I brought up, and so did my colleagues over here, on the legal issue of this.
all right, Representative, that is not a legitimate point of order. You disagree with Representative Canario. I think we all get that, and we can come back to you for another argument. We'll be happy to. Let Representative Canario finish, and I'll come back to you. All right, Representative? Thank you. Thank you. Continue, Representative.
Thank you, Mr. Speaker. I apologize if I caused any hard feelings between myself and the good Representative Almeida, because that was not my intent. My point is, we're just trying to get those people who are abusing the system and get them to stop. That's the whole point of this thing. Thank you.
Representative Almeida. This is your third time, Representative, but I'm making an exception, so proceed.
Thank you, Mr. Speaker. To Rep. Canario. Hey, I appreciate it, my brother. I know where you're coming from. I don't take it personal. There isn't nobody up here I wouldn't mind having a beer with in pretzels and having a good time. But when it comes to politics, there's a different Joe Almeida. We know that because you like the AG's office. But the fact is, there he goes.
Representative, what is your point of order, Chairman?
Would you like to explain that comment, Joe?
That's not a point of order,
That's
folks.
a point of order.
What was the comment, Representative?
Of course you know, you're like the AG's office. So Doc Corvese is right, but that's the street in me coming up.
All right, Chairman, he is allowed to say that those are not legitimate points of order. We all have our own opinion. So thank you all, but you did the same thing, Representative Almeida. You can't stand up on a point of order if you disagree with debate. We can respectfully disagree with one another, and we get up to make our own points in our own time. Proceed, Representative. Thank you.
But let you know, I did acknowledge what I said to Doc Corvese. That's just Joe Almeida in the street and me coming out. The purpose of this bill is, in fact, what rights are being violated by the next step that we're going through, as other reps have talked about HEPA and a few other issues. That's what I'm talking about. We understand, and I agree with the gut of this bill about stopping people from using drugs for other purposes and selling them on the street. I get that. But sometimes, or once in a while, we decide when we're going to add personal issues, not personal issues, but issues that become personal within a piece of legislation to act as if it's okay and all right. Well, I brought up a whole lot of issues here that I feel as though are personal, that should override the legitimacy of a so-called bill. This bill doesn't have legitimacy, does not have, to me, is not following the course of law that I was trained for. I was told when you go up on a scene, you judge that person for what he or she did, and not to put your personal feelings into what you think you might see. Be it known to all, your eyes do not tell you the whole story. And that's why law enforcement is built on the 5 W's and the H. Who, what, where, when, how. All of a sudden, it gets lost when it's written. Thank you, Mr. Speaker. My apologies to you, Doc Corvese.
Representative McCannon.
Thank you, Speaker. I have a question for the sponsor, if he would yield.
Chairman McNamara will yield. Proceed.
Thank you, Chairman. Chairman, I'm directing your attention to page 7, line 4. There's a phrase, prescription drug monitoring database. And I've had some involvement with this in my professional life. Is that a database that has personal information of patients, or is that simply a database for the prescribers?
It is a prescription database. It does not have general medical records, and I think that's an important distinction to be made here, Representative McKinnon, because the discussion has been about medical records. This is strictly a prescription monitoring database.
And to clarify, it would not have, if you're my doctor, it would have the fact that you prescribed a certain amount of a drug to me, your patient, but it would not have my name.
It would not have your name.
Thank you.
Representative O'Grady.
Thank you, Mr. Speaker. Question for the chairman, if he'll yield.
He will yield.
Thank you. Chairman, I want to direct your attention to page 8, specifically line 25, which says that, well, actually line 26. Referring to the director, it says, thereafter, the disclosure of information pursuant to this subsection A5, which is the carve-out from the warrant process for the Attorney General's office and others. It says that this section shall automatically renew for successive one-year terms unless the director provides written notice to qualified law enforcement agencies and or the Speaker of the House and President of the Senate that they no longer wish to provide this information. So am I reading that
Correct.
The director has the unilateral right to undo a statute that we might pass here today?
Correct. There is a sunset provision.
Which is not called into play unless the director wants it to be called into play.
Correct. And there are also, above that, line 20 through 24, failure to submit verification forms under section 5(4) of this section shall be the immediate suspension of disclosure information there is criteria that the director shall have relating to this.
Okay, thank you. Ladies and gentlemen, I'm not sure that I've seen a statute like this which is in play unless an administrative head decides that he or she no longer wants it to be in play. It's the first time I think I've seen this, so that's interesting and something that I'll consider. Thank you.
Representative Newberry.
Thank you, Mr. Speaker. Question for the chairman, if he'd yield.
Yes.
I want to address the sunset provision that Representative O'Grady just brought up.
Yes.
Why are we doing that? We passed a lot of legislation. Let me finish my question.
Wait,
Sorry, no offense, but just... We pass a lot of legislation in this chamber that has sunset provisions. Sometimes we're not certain about things, and we put a year in, and we come back, we pass probably 10 bills a year, we extend the sunset provision. Why are we giving a department head the right to do that? Why are we not doing that? It doesn't make any sense to me at all. Unless we're... go ahead, sorry.
Yeah. We have in the past legislated sunset provisions, and probably the most notable sunset provision was in our first medical marijuana bill. Why would we do that? We would do that to ensure, particularly in this case, that maybe one doctor wasn't writing the majority of prescriptions. It was a new program, and we had doubts about how well it would be administered. So we put a one-year sunset provision in that. In this, we are giving the individual who heads the Department of Health, the director, usually a physician, the ability to evaluate this as it goes and make recommendations.
All right, so we are essentially delegating away authority to a department director to decide whether, in the end, it's a good idea that we're, I don't want to overstate this, but going around the warrant requirements for criminal prosecution. This bill makes absolutely no sense to me. Way back when this debate started, Representative Bennett gave the best argument in favor of this bill. I understand what you were saying, but I've seen absolutely no justification from any of this debate for why this bill needs to be passed. It's a bad piece of legislation. We should vote it down.
Representative Walsh.
Thank you, Mr. Speaker. Respectfully, I would like to clarify that in the database that we're speaking about, it says specifically in the bill that the patient name, prescription, and dosage are in the database. Additionally, if you look on page 4, section 27, marijuana is included in this. Now, I'm sure all of you are well aware that Rhode Island has medical marijuana, and I'm sure that you all are aware that federally, marijuana is still illegal. So this means that we would be giving the FBI, the DEA, and the Attorney General the right to look into medical marijuana patients' prescription histories without a warrant and charge them with a federal crime. That is insane. My apologies. Thank you, Mr. Speaker. I will still be voting no.
Representative Mendoza.
Thank you, Mr. Speaker. Would the chairman yield?
Yes.
Mr. Chairman, did anybody on the committee, or has anybody on the committee actually have a printout of what's in the database? Is there any experience with anybody who's actually looked at the information that's in there?
In the past, when we were legislating this, I believe the database is described in the bill.
But, okay, so there was never like a sample printout of any of the screens submitted to say, okay, this is really what it looks like?
No.
Okay. Thank you, Mr. Chairman. Just to reiterate what a lot of my colleagues have already said, that, I mean, this is a fundamental right that we're talking about, and you know, the basic, you know, purpose of law is to go before a judge if you think that there's some activity and obtain a warrant and then, you know, and then execute that warrant. This is very sensitive information, and we've heard some conflicting information by the debates on the floor. I know that there's good intent here. It appears to me that this actually creates a bigger problem and more concerns than the benefits we may reap from it. So I recommend that you oppose this bill. Thank you, Mr. Speaker.
Representative Lombardi.
Thank you, Mr. Speaker, and members of this honorable body. Representative Walsh kind of took a little bit of the steam. I also point you to the definition section, page 6, item number 46, ultimate user, and it defines who would be subject to this. So I think that buttresses what she said. Mr. Speaker, to me, this is just an assault upon our constitutional rights. Big Brother's watching us. 1984. They're going to get this. They're going to get this information, and they're going to draw inferences. So someone's got marijuana, Vicodin, whatever, OxyContin. They're just going to draw some inferences from this, and it's really, really scary. They're carving away at our rights. If someone is abusing the system, Mr. Speaker, there's a process for this. Go get your search warrants. Get your CIs, your confidential informants. I was going to say something else. I'm sorry. And do what you got to do. That's the way you go after this, not by carving away at people's constitutional rights. This is what I do for a living. It scares me because what's next? And what will happen is, by looking at the records, they will draw inferences about your character. They will draw inferences about what you're involved in. They will draw inferences about who that individual is. I urge everyone in this room, please do not pass this. This is an abomination. This is an assault upon our constitutional rights. Please, we're going too far on this. Thank you, Mr. Speaker.
Representative Ucci.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I rise in support of this legislation. We have an opioid and drug crisis in our state. We had the foresight to put together a database. We need the tools in place to properly look at what's happening when these drugs are being prescribed. We need the teeth to understand the scope of the problem. We've all gotten the calls from constituents about their child who's gone down the path that needs help and needs help to get into residential treatment because it starts off with prescriptions and it ends at something else. I don't know, and I respect Representative Lombardi, he's a good friend of mine. I don't know who the they are all the time. But we need to do something to combat this crisis. We need to give law enforcement the tools to get to the people who are overprescribing. And I'll say it, even if it's marijuana. Even if it's marijuana, because that can cause problems. But the real problem is in the opioids. It's in the pain pills. And we need the tools to look and see who's doing it wrong, and to do a proper law enforcement investigation. We have remedies available to us under the law if the police overreach, and no one wants to be at that point where they're doing that. But the last thing our law enforcement is going to do is to look and see what Stephen Ucci is doing in the database. They're going to see who's in there overprescribing and start to understand why is this one doctor prescribing more than others, and start to look into it. And maybe just the inquiry, that knock on the door that says, Dr. X, why are you prescribing 10 times more than everyone else, will stop them. So we are in a crisis right now. And unless someone has a much better idea of what to do right now on this to stop it, I think we should vote this and move on. Thank you, Mr. Speaker.
Representative Lombardi.
Thank you, Mr. Speaker. And I totally agree with my colleague with respect to, if there's a bad doctor, set an example. That's what you do. And trust me, in that industry of drug sales and abuse of drugs, there's enough confidential informants in that industry that you could fill 1,000 rooms with. The they is the big brother that's looking at us. The FBI, the DEA, and whoever else. because we have no control over that. But here's the most interesting thing, Mr. Speaker and members of this auspicious body. They're concerned about the opioid treatment and the abuse. Well, guess what? Opposed to warrantless searches, and that's what this is, a warrantless search. The Opioid Treatment Association of Rhode Island, the Mental Health Recovery Coalition of Rhode Island, the Mental Health Consumer Advocates of Rhode Island, the Mental Health Association of Rhode Island, the National Alliance of Mental Alliance of Rhode Island, Office of the Mental Health Advocate. But remember, the Opioid Treatment Association of Rhode Island is opposed to this. That should tell you. This is a slippery slope. Please don't do this. It's an assault upon our constitutional rights, and that's all. Thank you, Mr. Speaker.
All right. Thank you, Representative. Volume matters. Let's get it all down a little bit. Everybody just down. I appreciate the robust debate. It's excellent. We get two viewpoints that are getting out there. Volume matters. So we're all good of hearing. Whip Filippi.
Thank you, Mr. Speaker. And I know this is my third time, and I appreciate your indulgence. Representative Ucci asked for a different idea, and here's a simple fix for the bill. Why don't we just say, when you're requesting patient information, you only get someone's initials. And if those initials lead the police to probable cause that a crime has been committed, at that time, they can obtain a warrant and get the person's full name. The information in this database is someone's first and last name. Let's say the department can only hand over someone's initials. If that leads to probable cause, go get a warrant, and then you can get the person's first and last name. That's an easy fix to this bill.
Representative Lancia.
Would the chairman rise for a question?
He will proceed.
Chairman, I just had a couple of quick questions. I think it goes back to something that Representative Newberry said. The sunset provision, year by year, is controlled by the department director working with the law enforcement agencies. Is that correct?
Correct.
So once we vote this, we essentially are out of the equation?
No, there is a definite sunset provision, 5-year sunset provision.
Well, my point is that the information is shared between the law enforcement and the director, or the director. But going back to some Representative Ucci said, who to deal with, how to deal with it. Is there a requirement that anything that's collected or done, is there a reporting requirement back to the General Assembly?
Yes, there is.
And at what point would that be? Would it be yearly, or would it be at the end of the sunset, or when the director decides it ends?
It's listed, 1 minute, I believe, on pages, page 8, lines 20 to 33.
Okay, just looking quickly. So he would be reporting to the General Assembly every year?
He would, or she would, annually thereafter review the disclosure information, yes, annually disclose to the Speaker of the House, the President of the Senate.
Okay, so it would go to the Speaker of the House and the Senate, and then they would decide what, if anything, they wanted to do based on what they hear?
Yep.
Okay, all right. Thank you so much.
Representative Price.
Thank you, Speaker. I guess my question is, we obviously have an opioid crisis. Is this a crisis of opioids that are being prescribed, or is it opioids that are on the streets that are not prescribed? If are we addressing I guess my question is to the sponsor, if you would yield.
He will yield.
The crisis is, could you describe the crisis to me? Is it a crisis of prescribed opioids that are being let out into the population, or is it crisis of opioids that are illegally out onto the out into the population.
The story that many of us have heard from our constituents and at those wakes and funerals that we've attended sometimes start with someone who has a chronic injury or pain. They are given a prescription medication. After they fail to be able to obtain more of those prescription medications and they are still in pain, they turn to people in the street that are selling products that relieve that pain. One of those products is heroin. Much of that heroin is mixed with fentanyl. That is a very common thread of a story that we've heard. What this bill attempts to do is look at those physicians and prescribers who are creating what might be called pill mills. And if you were to go to a recovery center or speak with people with addiction issues, they know who they are. That's what this is attempting to stem. People that are prescribing outside of their boundaries and are making money through the pain and heartbreak of these families. That's what we're attempting to do, Representative Price, is stop them.
Thank you, Chairman. So if I understand you correctly, so we're addressing the pharmaceutical companies that are essentially being the progenitors of the gateway drug to further drug addiction. Is that what we're trying to? So this addresses the over prescription of pharmaceuticals that
right, for profit.
For profit.
Yes.
Okay, so that okay, I think I understand now.
Thank you.
Yep, thank you very much.
Mr. Speaker, also, earlier I said in terms of with Mr. McKinnon, Representative McKinnon, the prescriptions do have the patient's name on it, the pharmacy, the doctor who prescribed it, so that information is on the prescription, and that's what's on the medical record. Just want to clarify that. Also, Mr. Speaker, the Supreme Court ruled in Wayland versus Roe in 1977 that this is not a violation protected by the 14th Amendment. Thank you, Mr. Speaker.
Representative Solomon.
Thank you, Mr. Speaker. I rise in support of this legislation. I feel like every time I open up the Providence Journal, I'm reading about another drug overdose death. And as Representative Ucci said, there is a serious crisis in the state of Rhode Island. In 2015, there were 290 deaths. In 2016, that number increased to 326 deaths. How many more are we going to see in Rhode Island in 2017? This bill, I feel, will finally solve that issue. Because although many of those deaths are occurring because of heroin and fentanyl, they're starting with something else. They're starting with prescription drugs. Someone out there is overprescribing these drugs, and then they're eventually moving on to something cheaper and easier to get, and that's heroin and fentanyl. So I believe this bill will solve that issue. Thank you.
Representative Natalillo.
Thank you, Mr. Speaker. The chairman yield.
He will yield. Proceed.
Chairman, we can hear that the whole chamber has the same feeling as the next person next to them in regards to the addiction crisis. But there's also the balance of the privacy issue. Now, as the whip just said, if the full name isn't disclosed, the privacy is still kept there, but the database will disclose the red flagged information. Is this something that you might consider as a compromise in solving the issue of tracking down the abuse of the potential of pharmaceutical overdose, over prescription, over being overprescribed, but yet we're meeting the needs of the privacy issue. That's the opposition to this, is that it's concerned that this full first and last name is disclosed out there. And your concentration in this legislation, from what I hear, and we can all agree, is that we want the abuse to stop. We want to stop opening the newspaper, as the rep said, or myself being in the funeral service industry, catering to the needs of families with the drug addiction. But the privacy concern is that's what we hear here. Is this something that you can address so that it's satisfied? And that way we can address this situation satisfactorily between all of us here.
First of all, Representative Natalillo, to you and your profession, I have to give you credit for dealing with a situation that has to be horrific, and we know that it's changed the role of your profession, and many of the individuals in your profession have done a great job to meet this need. Secondly, when a patient, when someone overdoses and they investigate, they say, well, where did they get the Oxycontin? Where? Jimmy Smith down the street. Well, the DEA, where did Jimmy Smith get it? Let's start with Jimmy Smith's records. We find out Jimmy Smith, he not only went to one doctor, he went to his doctor in Coventry, but then he went to Warwick, went to Providence, another doctor on the east side, and had multiple prescriptions. And what was he doing with those drugs? Unfortunately, that is one aspect that we couldn't do. I would support and am supportive of protecting privacy. However, I am not supportive of doctors that are operating pill mills that are making money from these unfortunate suffering of individuals and the addiction of individuals. That's what this is about. But I appreciate your concern. If there was a way to do it, absolutely yes.
Thank you.
Leader Morgan.
Thank you, Speaker. I know everyone in this room is sincere, and I especially appreciate that you want to stop the deaths from opioid addiction, that really the carnage that's going on out there, whether they die or not. It's carnage from the opioid crisis that we have. And yet, the right to privacy is very important as well. And I'm just wondering if we look at line 17 on page 9, if we could just say the patient identification number, then the authorities could find patterns without revealing the identity of the persons involved. It still protects privacy. It still allows the police to find patterns of abuse because they can track the patient identification number. And we kind of get both things that we want. Just a suggestion.
Representative Ucci.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I'd like to echo what Leader Morgan said. I know all of you very well, and there isn't a person in this room who doesn't understand the severity of the opioid crisis. And the privacy issues are very serious. And we always balance what we need to do versus privacy issues in everything we've done. But I'm going to use myself as an example. If they go into this database and find Stephen Ucci and all the prescriptions that I've gotten those from doctors. I haven't done anything wrong. It's not illegal if I have the prescriptions, if I have a legal prescription to have these. So that's what you're going to, if the law enforcement's looking at this, they're looking for those who are who are writing the prescriptions, who are abusing it. Most likely because some harm has been done to the person for whom they're looking at. So I understand there's a privacy right. But it's not looking at the individual, because by definition, if you're in the database, unless your name has been forged, then you've gotten this from a doctor who has the opportunity to write prescriptions. If I have a drug problem and I've been getting extra pills from different doctors, that doesn't mean that I've done anything wrong if they've written me the prescription. So you have to balance that off too, is if they're in the database, what are they going to be charged with? So we really have to look at what is this trying to do. This is meant to give law enforcement the ability to go in and look at this and find those instances where we have people in our medical community who are abusing the process. So that's why I'd ask you all to support this. Thank you.
Representative O'Grady.
Thank you, Mr. Speaker. I wasn't going to get up a second time, but Representative Walsh said something earlier that has really stuck with me. And what she pointed out is that this bill and the database that this bill allows our Director of Health to reveal to federal officials also includes prescriptions for medical marijuana. And while some of us in this room unfortunately do know people who have overdosed from opioids, I'll bet all of us in this room know someone who has been prescribed medical marijuana to deal with some issue or another. My wife's best friend right now is in hospice care for metastasized breast cancer and avails herself of medical marijuana. And my concern is that this will have a chilling effect, not on the patients, but on the doctors who are prescribing medical marijuana to those patients, despite the fact that it is banned at the federal level. And I think we've done a lot in this room over the last 10 years to expand the use of medical marijuana. Just last year, I think we passed a bill that allowed its use for PTSD. And so I would be very concerned with this bill as written that will put a chilling effect on something that we know is a useful alternative to pharmaceutical synthetic drugs that are really the root of our problem here. So I would ask us to really think twice about this bill. Thank you.
Leader Shekarchi. Last slide.
Thank you, Mr. Speaker. Appreciate the very spirited debate. As the Speaker said, it's always good debate. And I won't belabor a lot of the points that were said. I know there's some people who don't like this bill and are going to vote red. And I know there's some people who like this bill and are going to vote green. I want to talk about the problem we have. In March, the Attorney General wrote a letter to Chairman McNamara on his bill. It talks about the need and the want and the why and why we should have this bill. What he said in this letter was, it's unfortunate that Rhode Island continues to lead the nation in illicit drug use. Even more disturbing, we have been the eye of the storm of a heroin, fentanyl, and prescription opiate overdoses. While the state has made great strides providing naloxone to our communities and police departments, we have one of the worst opiate crises in the country. And we have to make a decision today on this bill. We have to balance. And my dad's a doctor, and Doc Corvese is a doctor, and I hold them both in the highest regard, because becoming a doctor is a calling in life. And they have a license, but that license is not absolute. That license is regulated by the state. And with that regulation comes responsibilities to act responsible for your patients, and comes the obligation to cooperate with state and federal authorities when your license or your ability to practice is called into question. It's not optional, it's a requirement. What we're doing with this piece of legislation is trying to attack a problem that does not have easy solutions. We have to balance, as Representative Bucci said, we have to balance and make a decision. What is right? Are we going to pass a piece of legislation that is a little bit unusual because it has the director, it has the ability to stop the program, Dr. Alexander Scott, who I have the most highest respect for, who performs her job every single day. There's not an ounce of politics in that director. It's all about the public safety and health of the citizens of this state. It's probably one of the governor's best selections, if not the best of her cabinet. We have to make this decision. And there was a whole argument and discussion, rightfully so, about the legality of this. Chairman McNamara talked to a Rhode Island case in the early 90s or late 90s. Well, I have some information from the Ninth Circuit Court of Appeals that was decided on Monday. And it decided that the Oregon prescription drug monitoring program, very similar to Rhode Island, is constitutional, is legal, and is perfectly acceptable. I won't read the 16, 17 pages of opinion, but I want to just state where the theory of law rests regarding the program like this in Oregon and hopefully the one we have in Rhode Island, similar to what Massachusetts does and another New England state, I believe. But it's under the federal preemption of the Controlled Substance Act. So we may not like this and you may want to vote against it, and that's fine. But don't vote against this because it's not legal or not proper, because the Ninth Circuit on Monday came down with this decision and said that it is. This is a solution. Is it a perfect solution? Is it the best solution? But unless someone comes along with a better one, I'm willing to move forward on this for 5 years with Director Scott having the ability to stop it if she feels it's being abused or not being done right or not effective. Because as Representative Solomon said, we have to do something. We have to do something because our young people are dying. And your decision today is a very personal one. It's not a political one. I'm not going to ask anybody to vote red or green. I'm just going to ask everybody to please do the right thing in your conscience. Thank you, Mr.
Leader Moore.
It's a good speech. And I know everyone here is sincere in wanting to stop the opioid crisis. But do we balance our rights away? Or do we try to find a way to accommodate both? Sometimes in crisis is when we need our rights the most. When there is something horrible in our society and we want to protest or we want to speak out against it. Do we balance away our rights then? That's when we need them the most. So I know we have a crisis, but I think there is a solution here so that we can address the crisis without putting people's right to privacy at risk. Because those rights are important, and they're most important when we are in a crisis, when we need those rights. I think with a little work that Chairman McNamara could come up with a good solution here, and perhaps we just give him till tomorrow to think about it, because making the decision right now on the floor with this debate going on is hard for him to think through the ramifications and the implications. But I think we can do this. I think we can find a solution that protects patients' right to privacy and still catches the bad guy and stops this crisis or makes the crisis less of one. So I urge the chairman to ask for a day so that he can consider what might be a good solution here.
Leader Shikachi.
Thank you. Leader Morgan, I appreciate the words, but everyone, I think this is a good bill, and I'm going to vote for it. And I think this attacks a problem that we have today in Rhode Island, a very serious problem. I would hope everybody would vote green. I think it's a good bill. Thank you.
Clerk, unlock the machine. There are no other lights. All in favor, please vote green. Those opposed, red. Clerk, lock the machine. 46 in favor, 21 opposed. The act prevails. Next item, clerk.